Okay, while I'm waiting for the digital projector to warm up here. Today's our second to the last class. What I'd like to do is end about 15 minutes early and have you guys fill out evaluations. I understand you've already done evaluations for your sections, so this will just be for me and for this class. What I need is a volunteer who can hand these out and collect them and take them back to the legal studies office. And would you do that? So we'll stop, and then please don't leave until you fill these out. It's really, really important for us, and we really appreciate your input. Okay, so it's really hard for me to kind of end this class with so much in my mind left sort of unresolved and on the table. But I want to try to use the next 2 days. I want to try to talk with you about the Brown versus Plata case, which I asked you to sort of reread the first part of, and hopefully some of you will poke around in other parts of it after you think a little bit more about the lecture. And then today I want to kind of focus on what it means to confront exactly what we did here in California in terms of what mass incarceration produced. I think I think it's horrendous. There's a kind of atrociousness to it that we ought to wallow in a little bit before we move on too easily. But then wanting to end on a better note, on Thursday I want to turn to sort of what this kind of forced confrontation with the humanity of prisoners and the sort of shame sanction delivered by the Supreme Court what direction that might point us in terms of a more hopeful future for punishment in California and perhaps across the country. So the healthcare crisis that accumulated in California over the last 30 years or so, and very much a product of mass incarceration, is not something that very many of us in the study of punishment or criminology really saw coming. For most of the history of prisons have basically been about younger people, and they've generally been about relatively short periods of time in people's lives. Of course, there's always been long sentences for some, life imprisonment, etc. But by and large, the average prisoner was a young person held for relatively short periods of time. And while across the history of punishment, there's plenty of moments of atrocity, prisoners worked to death in both northern prison factories and southern convict prison factories and plantations. Prisons beaten to death or murdered across the 20th century in prisons that were often run largely by prisoner trustees because of the lack of professional guards, etc. But the kind of aggregated mass-scale atrociousness that I think the California medical crisis, and it's really just the tip of an iceberg of a medical crisis in corrections across the country, very much again a product of mass incarceration, is really raised a different kind of a question, which is whether or not prison, at least at the scale that we try to operate it, can really function in a way that doesn't amount to torture. Torture is a theme that in some ways runs through this class. In fact, I've often thought it would be interesting to reframe the class around the question, why not torture, or why have punishment that is different than torture? And maybe this would be a good moment to review some of the themes that we discussed in the class. After all, if you look at the history of punishment as we have, and visit scenes like the scaffold hangings that took place at Tyburn and across the United States as well in the 18th century, public executions, very painful, physically prolonged, painful deaths, often accompanied by a great deal of psychological torment. And one of the more remarkable features of the history of punishment is this notion that there's something wrong with torturing prisoners or subjects of punishment, that the prison and modern forms of punishment are supposed to prevent that. They're supposed to give us a form of punishment that can satisfy the needs, both psychological and cultural, of punishment without resulting in torture. And if you will, and this is kind of the theme for today's class, the question that Brown versus Plata really raises is whether we've really gotten very far from the scaffold, whether torture is not a kind of endemic, and in this case, highly bureaucratic and structural feature on a mass scale of punishment. But that kind of begs us to review the question, what's wrong with torture? After all, if we go back to sort of what we might take to be the psychological, even biological roots of punishment in evolution, a desire to seek some kind of revenge or retribution, to put it in more rational terms, against a wrongdoer, appears from a lot of experimental research to be a very deeply anchored, perhaps instinctual feature of human psychology, one that may in fact be explained by evolution. If so, one thing that's clear, from the look that we've done at the history, torture, and by torture for now, let's just say what we mean by that is, subconsciously, deliberately, physically, and psychologically painful punishments intended to deliver severe, intense pain, both psychological and physical, and to make that perfectly clear and visible to anyone who's watching. After all, from a perspective of seeking that kind of revenge or retribution, any kind of modern punishment, prison or jail, let alone probation or restorative justice or other kinds of sanctions, may appear to be very unsatisfying compared to being able to deliver painful treatment to a wrongdoer in a public setting like a scaffold. If deterrence, which is perhaps a more modern way of understanding punishment, sort of arises also in the 18th century around ideas of democracy and free markets, etc., but has become certainly one of our more foundational views of punishment. We might disagree as to whether torture is necessary for deterrence, and indeed we saw that Beccaria and Bentham both thought that a proper regard for deterrence would point us toward lenient punishments. But from the point of view of terrifying and intimidating potential wrongdoers, torture, whether done in public, presumably the most effective, but even if done in private and advertised, or simply publicized that it had taken place, would arguably have a much more powerful deterrent effect than threats of long prison sentences, which is what we come to rely on in modern society. So, looking back and sort of thinking through not just our foundational purposes of punishment, but some of the sociological theories of what drives penal change over time, coming from Foucault, Durkheim, and Marx, and others, why don't we torture? And it's one of the interesting phenomena of our current period that we may in fact torture. That's the question I want to explore with you. But we certainly don't think it's right to torture. In fact, as we'll see in a minute, we've got laws in this country against torture, and indeed UN conventions that we sign against torture. We don't sign conventions that require us to not execute people. So capital punishment is on the menu, but torture isn't. And it's something that sort of before we sort of look hard at the question of whether in fact torture is a fair description of what was done in California, we ought to ask at least review in our minds whether we have a good understanding of why we don't torture. I mean, maybe after 14 weeks the answer isn't very obvious at all. In which case that raises its own puzzle, I suppose. But what are some of the reasons? Either normative reasons why we shouldn't torture, or simply sociological reasons why we don't torture, or at least don't brag about torturing. We're embarrassed and shamed if we turns out we are torturing. Right? Why not? Why not torture? Please.
Punishment is supposed to alleviate crime, so I think torture is largely seen as a crime itself, so it's not really seen as a solution, but it's more like aggravating all the problems are there.
So historically, we may have felt a desire to reach out and wreak some kind of vengeance on the wrongdoer, even before perhaps we had a state to do so. But at least today, when that reaching out and punishing takes the form of some kind of violent assault on the body or pain, we might want to parse a little bit more closely what it is that we don't like about torture, right? Because maybe there's a way we could reform it and have kind of a rationalized torture that might solve some of these problems and still be effective. But one reason is that our own modern values seem to suggest that torture is a crime. And in fact, as we'll see in a moment, torture is a crime not only in federal law, where as a requirement, as part of signing the UN's Convention against Torture, the so-called CAT agreement, we are actually required, as are all member states who have signed that convention, to make it a crime, and a serious crime, to torture. In fact, California, as we'll see, has its own penal code provision that makes it a felony to engage in torture. And indeed, if you kill somebody in a torturous way, that is a death penalty crime, right? It's an aggravated capital felony, so you can sentence to death, right? So we know that people died in California prisons during this prolonged Brown versus Plata set of unconstitutional conditions. So again, from some point of view, we have engaged in capital torture, murder. Although we're going to see there's some questions as to whether we can legally hang the term torture on the conduct. But yes, it's a crime, and although there's a bit of a contradiction, right? All punishment is about delivering harm that would otherwise be a crime in our society. We find you, we're taking money from you, which would otherwise be a crime if we weren't doing it subject to the law. If we lock you up, we're kidnapping you in effect, holding you against your will. So there's a sort of crime built into punishment. But I guess what we could say is that this is a crime that sort of stands out as offensive enough to our values that even under the framework of, well, lawful retaliation, there's something about it that doesn't sit right with our values. What else? What else don't we torture? Maybe we ought to have this conversation more often, because part of what perhaps we can learn from mass incarceration is that while we're totally against torture, we certainly weren't against the conditions that led to it, right? So maybe we need to be more candid with ourselves about the reasons we might torture people and then decide whether we're really involved in that. Yeah. We're going to come back to that, right? I mean, is torture just constituted by objective conditions that create intense pain or suffering or mental harm, or does it also require that you intend to do that? That it's your deliberate purpose to make somebody experience it? That's certainly our image of somebody who's heating up the pincer in the fire and then coming over to the victim and threatening to pull off pieces of their flesh or pull out their fingernails. That's somebody who has the specific intent, if you will, to cause pain. Here, as we'll see, the evidence in the underlying cases that became Brown versus Plata, the Coleman case, which dealt with mental illness, the Plata case, which dealt with physical pain and suffering, basically found that the state of California, as a defendant, was guilty of deliberate indifference. Right? They didn't necessarily intend to cause people or have the purpose to cause people terrible pain and suffering through medical neglect and malpractice, but they were deliberately indifferent. That is, essentially, they knew it was happening, and they just kind of kept on feeding people into a system that they knew this was happening in. Okay, but let's come back to that in a moment, whether or not we consider this torture. I still want to know, after 1,000 years of worrying about what went on the scaffold, and at least the last 300 years or so being pretty committed to notions like punishment should not be cruel and unusual under the 8th Amendment, in the language of more contemporary human rights conventions, punishment should not be cruel, inhuman, or degrading, not to mention torture. It should not include torture, which is considered sort of an especially egregious form of cruel, inhuman, and degrading punishment. But our ancestors had no problem with that. So what changed to make us queasy about torture?
It's almost linked to self-identification as being too civilized or educated, and people consider culture barbaric. And I think the more we evolve as a human community, we try to distance ourselves from being considered barbaric.
So again, visiting Dr. Durkheim, we know that punishments are deeply shaped by our collective values. Not only those that we feel like retaliating in the name of, which lead us to punishment, but also those punishments need to conform to our sense of values that evolve. And indeed, this notion of being civilized, it's an interesting term because we often use it as if it's describing some very high level of manners, like such a civilized occasion or whatever you might nice manners, nice food, nice clothing, etc. Civilized has a sort of upper crust, nice quality to it. And on the other hand, we also sometimes mean it as drawing a line between an acceptable society that we can identify with and one that is barbaric, that in some fundamental way retains unacceptable practices and values, whether they be child slavery or various kinds of power relations that exist in families, etc. There's a whole cluster of things associated with civilization that certainly we don't mean by that the line between the upper crust and the rest of us. We mean something like the floor of our society that we don't want to go below. And when the Supreme Court talked about what prisons have to be like in a quote civilized society, they certainly have in mind that we are all in some ways made uncomfortable, even ashamed, to see things, a punishment in our name that doesn't strike us as civilized. Now, Durkheim is sort of our go-to person on values, but let's bring Foucault into the picture as well, right? Does it behoove government and the state in our time to be seen as engaged with and complicit in acts of physical pain and torture, right? The scaffold story, we know that the king was well represented at the scaffold, and in many ways the scaffold was kind of a theater of the king's distinctive kind of authority and power, and the physical demolition of the victim by drawing and quartering, or literally hanging, with sometimes even more gratuitous mutilation of the body, was not something that power shrank from, but was something that actually nourished monarchy. Does torture fit well with contemporary government? Michelle?
Well, I'm thinking that society where people are demanding democracy, torture inevitably clashes with that, because people will see it as abuse of power at the point, like folks like that we have democratic change, that it is open and people being disturbed by this and subject by it, and therefore, if we have something behind closed doors like this, we might not understand it, and that it's something much less harmful.
There's a point at which the old gambit that the crowd at Tyburn and similar places would, in the moment of kind of carnivalesque cruelty over the body of the condemned, enjoy a kind of identity with and almost partial union with the monarch, kind of identifying with their power and their ability to just pulverize this enemy of the kingdom and the king's peace, passes. And in its place, we're left with this kind of discomfort because we don't identify with government in that way anymore. We might want government to serve us. We might even want government to serve us by dealing quite harshly with those that we fear. But the idea of a ceremony whose sort of central message is that the king is on a different level than the rest of us and he can crush any of us with his pinky if he wanted to is not a cheery thought in a democratic society, and indeed becomes something of an embarrassment for the state. Some weeks ago, I showed you the picture of the Florida electrocution, where there was a controversy in the late 90s because the victim had what either was a massive nosebleed or evidence of something more dire, although he's being electrocuted, so dire is in retrospect, isn't perspective there. But it was an embarrassment by and large. Some people tried to play it off as kind of a joke. Bob Butterworth, the Attorney General of Florida at the time, said, well, if you're going to murder somebody, don't come to Florida. Our electric chair may not be working too well, as if to kind of say, well, it's part of our justice system. But really, I think most people felt it was kind of embarrassing that even for a state that supported the death penalty, a reminder that torture, etc., happens is not pleasant. Well, again, we could spend a good deal more time on this, but I want that to be sort of in your mind as perhaps as you're reviewing the course. Is there a clear line that we can draw between torture and punishment? Do we know where that line is? It was once thought that prison would be a bulwark against torture, and yet as early as 1842, there was Dickens saying, no, this is even worse than hanging. And we've tried to reform the prison numerous times since then, and it still leaves the question as to whether there really is a difference between torture and punishment. Are these folks being tortured? Are some of them being tortured? Are they at risk of torture? And if so, is it the same kind of phenomena that it was at the scaffold? So let's go to this remarkable exchange in Brown versus Plata. This has not been much discussed, but I think it's actually the right way to read this case is to go to this first, because one of the most remarkable things about this case is that torture is actually mentioned, both by the majority, by Justice Kennedy's opinion, and in a response by Scalia. So let's look at the majority use of it for a moment. Here, Justice Kennedy's essentially explaining something that I think all of us need to explain to our family and friends when they kind of ask, how could it be that prisoners have a right to health care when Uncle Joe, who worked at GM for years but got laid off, doesn't have any health care until he gets to Medicare at 65? You've got to remind them that prisoners don't have a right to health care. They essentially have a right not to be tortured. Right? And so what the majority points out here is that prisoners are dependent on the state for food, clothing, and necessary medical care, not because they want to be, not because they came to the state and said, help me, I don't have enough, feed me, clothe me, give me medical care, but because they've been convicted of a crime and sentenced by a court to essentially a term of involuntary servitude, a condition very much like slavery, in which they have no control at all over their ability to get food, clothing, and necessary medical care. And so the court points out a prison's failure to provide sustenance for inmates, quote, may actually produce physical torture or lingering death, or a lingering death. And that's a quote from Estelle versus Gamble, a 1976 case, but quoting In re Kemmler, which is actually a case from the end of the 19th century that considered whether or not New York's early pioneering use of electrocution for execution was cruel and unusual. So it's actually a case about whether using electricity to kill somebody is cruel and unusual. They found it wasn't, by the way. But the point is, the concern that the court had with torture in the execution process is being raised here by the majority as something that is endemic in prisons when they are mismanaged or when they're deliberately run in such a way that they don't provide food, clothing, and necessary medical care. When that happens, it's the equivalent, if you will, of torturing somebody or a lingering death, physical torture or a lingering death. Now this drew the ire of Justice Scalia, who pointed out with sort of a certain amount of understated hyperbole here, the plaintiffs do not appear to claim, and it would be absurd to suggest, that every single one of those prisoners has personally experienced torture or a lingering death. And I just have to say that he was personally just deeply frustrated by this case, because it's really a remarkable thing to say, right? First of all, what if even one prisoner had experienced a torture or a lingering death at the hands of California's prison system? Wouldn't that pose a very serious constitutional issue? I think the answer is yes. But the point is the majority isn't, in fact, claiming that California has deliberately tortured anybody, but they are certainly making the case that the kind of suffering and the kind of pain that was generated on a very predictable and at a certain point clearly understood basis by California approximates torture. And so I think it's worth taking a moment to think about torture in a little bit more detail as legal studies students. And it's interesting in this regard, and it's hard not to imagine that in this case where the term torture is raised deliberately by the majority and in kind of rebuttal by the dissent, and in a case dealing with medical pain, that the recent controversy in American law about torture was not on the minds of the Supreme Court. So let me remind you of this notion of these memos that are known as the torture memos. These were memos that were written by members of the Justice Department's Office of Legal Counsel. That's a part of the Justice Department that closely advises the White House, generally the president, on top legal and national security issues. Shortly after, months after 9/11, this office was asked to basically review what constituted torture for the purposes basically of giving guidance to the White House and to the Defense Department and CIA through the White House as to how far American forces could go in using forcible techniques of interrogation and confinement without crossing the line into torture. And as you know, these are rather infamous. In fact, the memos themselves have been criticized on some points, but on other points they're very interesting reading because they really provide a thorough, not thorough enough perhaps, but a nonetheless a wide-ranging legal memo that covers various materials to try to discern the question, what does torture mean for purposes of federal law that makes it a crime? And as you'll see, they go out of their way to basically kind of highlight the difference between criminal torture and things that may come awfully close but fall short of that, because clearly, again, at least unstated question overhanging the torture memo is how far can we go in using physical pain and other conditions to try to get information in the context of the war on terror. So first note that the U.S. Is a signatory, as are most of the countries, not all of them, to the UN's Convention Against Torture. Article 1, Section 1 of which defines torture as such: any act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person for such purposes as obtaining from him or a third person information or confession, punishing him for an act he or a third person has committed or suspected of having committed, or intimidating or coercing him or a third person, or for any reason based on discrimination of any kind, when such pain or suffering is inflicted by or at the instigation of or with the consent of or acquiescence of a public official or other person acting in an official capacity.